Hello, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today, we have a great webinar on required lien notices to the owner and general contractor for both residential and commercial projects. What to send and when are they due? By construction lien law expert Don Overton. Without further ado, I would like to introduce Don Overton.
Hi, my name is Don Overton. I'm here in Little Rock, Arkansas. Arkansas doesn't recognize a specialty for construction law, but it is what I primarily do. I'm a licensed contractor and an attorney. I like to tell people that I'm a contractor that practices law as opposed to an attorney that dabbles in construction. So this topic is near and dear to me, and it's a large part of my practice, and as anybody on this call probably can agree and attest to, with interest rates climbing and the state of the economy is in, for contractors and subcontractor suppliers getting paid, we're back in the 07, 08, 09 era where it's becoming increasingly difficult to get payments. And so while a lien is not an end-all be-all, it is a nice tool to have, because it gives contractors, subcontractors, suppliers an extraordinary remedy that's not available to other creditors literally anywhere else. So let's get into the lien notices, because as anybody that's dealt with liens knows, if you don't get the notice done right at the beginning, then you can end up shooting yourself in the foot. And even if you do everything else right, if you miss the very first step, your lien can be declared invalid, and then you have to go to the back of the line, back with everyone else, and try to collect payment. So let's get started. And so before we get started, anybody that's on here, either write down or try to remember these four numbers: 4, 10, 74, and 120. If you're doing residential work, you need to know 4, 10, 74, and 120. If you're doing commercial, you just need to know 10, 74, and 120. It's really important to know those, and we'll get to what those are as we go through the slides, but I just want you to write those down: 4, 10, 74, and 120, and then we'll get started. Okay, so the lien law in Arkansas is found at 1844-101, and then it goes from there. I think it goes to 132 or 138. So we're going to hit the notice provisions, which start with 1844-114. So here's the 10. So every person who wishes to avail himself or herself the benefit of the provisions of subchapter shall give 10 days notice before the filing of a lien to the owner of the building or the improvement that she holds a claim against, setting forth the amount from whom it's due. So there's your 10. So you can't just file a lien in Arkansas. You've got to give the property owner 10 days notice. A lot of people ask why you have to give 10 days notice. Well, that 10 days notice is to give the owner an opportunity to research and verify if you are owed the money, because obviously they don't want to pay twice if they've already paid for your work. If you're a subcontractor, they've already paid the general, or if you're a supplier and they've already paid the general who's already paid the subcontractor. Additionally, that notice not only has to go to the owner. If you're a supplier, it needs to go to the subcontractor that bought it from you, the general contractor on the job, as well as the owner. If you're a subcontractor, it needs to go to the GC and the owner. If you're just a general contractor, it just needs to go to the owner. So basically, you've got to notice everybody up the food chain that you're owed money. So then let's get to 120. So that's 1844-117, the filing of a lien. So any person who wishes to avail himself of the provisions of the subchapter has a duty to file with the clerk of the circuit court, the county where the building or extra other improvement to be charged with the lien is situated within 120 days after the things specified have been furnished or the work or labor done or performed. So you have to file the lien in the county where the property is located. That's usually pretty straightforward. However, there's some areas where a property, Little Rock, for instance, there's an area in southwest Little Rock that has a Little Rock address, but it's actually in Lien County. And so you've got to make sure you're in the right county, because most people would think Little Rock's in Pulaski County, but there's some areas in southwest Little Rock where they've annexed some areas. And then there's other areas. There's a place, I believe, up in Jacksonville that goes from Pulaski up to Faulkner County. So there's a few areas. So you always want to make sure you file it in the correct county, because if you don't file it in the correct county, and you do it on the 119th day, you're not going to have time to fix it, file it in the correct county. So to the 120 days. So that's 120 days after the last day that labor was provided, materials were provided, equipment was provided, or the work was done. That 120 days does not include warranty work. It doesn't include punch list work. It doesn't include all that stuff. It's the last day work was supplied under the contract. That has tripped up some people in the past, and it's one of those things where people go, oh, well, I sent a bill for a late fee, so that resets my clock. No, unfortunately, that does not reset your clock. I've had mechanical contractors say, oh, well, we went out and checked the system and billed them $100 for that, so that resets our clock. Well, unfortunately, no, that does not reset your clock. So 10 days and 120 days, very important. The notice, you have to give them notice 10 days before you file the lien, and then you've got to file that lien with 120 days of the last day labor or work was performed, or equipment or services were provided to the job site. Okay, so then we're going to get to 4. So this question, for most people, this seems obvious, right? What's the difference between residential and commercial? Well, commercial is an office building, residential is a single family home. Simple enough. However, it's not simple enough. As it says in our 1844-115, the General Assembly finds that consumers who construct or improve residential real estate containing 4 or fewer units do not possess the same level of knowledge and awareness and need to be informed of their rights and responsibilities. That's talking about the owners. The owners of residential real estate don't have the level of knowledge and awareness. So there's an extra notice we're going to get to in a minute that you have to provide for residential. Where this trips people up, as far as suppliers, 4 or fewer units. So that means if you are a lumber yard and you supply lumber, windows, and doors to a spec builder in a new neighborhood, and that spec builder builds 5 homes in that neighborhood, not over a 5-year period, but they start 5, or they have 5 under construction, or there's 5 ongoing, or they're building them out in the neighborhood, which happens quite a lot. Obviously not in this economy, but that's generally the way spec building goes in neighborhoods. Once you build that fifth home under the lien law, now that becomes commercial. And so you don't have to build to the commercial code. It's still a residential structure. However, the lien law treats that as a commercial entity. So the general contractor isn't in the commercial, but that supplier, the lumber yard, is now looking at the commercial as opposed to the residential. So this is where it can get confusing. We're not going to spend a whole lot of time on this. However, this is something that I really feel needs to be pointed out, because this trips up some people when we get into some of the notices, because obviously the person that owes the money, that doesn't want to pay the money, that's going to try to fight your lien, they're going to pounce on this, and they're going to use this argument in an attempt to not have to pay you or to void or invalidate your lien. So then let's get to the notice. Okay, so this is the residential notice, right? Notice to owner by contractor. So no lien upon residential real estate containing 4 or fewer units. Again, that's our 4. Shall be acquired unless the owner of the residential real estate, the owner's agent, or the owner's registered agent has received by personal delivery of a certified mail a copy of the notice set out in the subsection. We're going to show the notice here in a minute. The notice doesn't have to be signed if it's delivered by certified mail. Courts have also accepted FedEx, UPS, DHL, anything that requires a signature. The residential contractor is also supposed to provide this notice before the delivery of labor and materials to the job site. Not just for themselves, but for all the subcontractors and suppliers that work on that project. Section 4, or subsection 4 there, which says if the residential contractor fails to give the notice, then the contractor might sell him or herself for the benefit of the lien. So if you don't give the notice before you start work on a residential structure, then you can't file a lien. You've waived your ability to file a lien. That's what I said before. So that's seems draconian to some people. However, as we're going to get later, the lien notices are for the benefit of the owner, not for the benefit of the contractor. So one way that you can make this, if you're doing residential work, that you can make this work, and this includes subcontractors, mechanical, electrical, plumbing, anybody that does residential work, not just commercial, is that you can include the notice in the contract. It can just be put the last page of the contract. It can be included in the text of the contract, but it has to be set in all boldface, and it's got to be in all capital letters, and it's got to be worded exactly as on the next slide. So this is the notice. It says important notice to owner, and it has all this exactly. So I understand that each contractor, subcontractor, labor, supplier, architect, engineer, surveyor, appraiser, landscaper, abstractor, title insurance, supplying labor, service, material, right? You can read that. The reason I underlined the contractor, subcontractor, the previous version of the notice said, I understand that each person supplying labor. If you have a notice that says each person and doesn't say each contractor, subcontractor, labor, supplier, then your notice is no good, because under subsection 7, it says worded exactly as stated in all capital letters. If it doesn't have it exactly with these words, it's not valid. If you leave off an and, or you leave off a the, or you misspell a word anywhere within there, then it becomes invalid because it is not worded exactly as stated in all capital letters. If you don't put it in boldface, it's void. If it's not in all capital letters, it's void. It's got to be exactly word for word, all capital letters, and in boldface, or else it's not valid, and then you cannot file a lien. So then let's switch over to commercial. Like I said, so commercial is office buildings, schools, all that stuff. It's also 5 or more residential structures in a neighborhood or a development. So let's look at 5A. This trips a lot of people up. It's excuse me, it's part of the frustration with the legislature sometimes on the way laws are written. I share your frustration. It's frustrating to me too. I've discussed this several times to try to see if it can get redone, and nobody, it can't get redone. So here's what it says. The notice shall be sent to the owner, the owner's agent, owner's registered agent, and to the contractor before 75 days have elapsed from the time that labor was supplied or materials furnished. So that's why I said the number, you need to know the number 74, not 75. I've had clients over the years that come in and say, well, I know I've got 75 days to send the notice. No, it says before 75 days have elapsed. So that means that the last day that you can send the notice is the 74th day. And that's 74 days after the last time that labor was supplied, materials or equipment was furnished under the contract. Again, late fees, don't extend that out. Going back to do warranty work or to check on something so you can bill them doesn't extend that. It's 74 days from the last day labor, materials, or equipment were supplied pursuant to the contract. And that's that 74 days comes up quick in commercial. Anybody on this that has done commercial as a subcontractor or as a GC, but especially as a subcontractor, understands that on a large project, you normally don't get paid immediately, because you'll turn in your pay app on, say, by the 25th of, let's say, the 25th of June. the contractor turns that in the 10th of July to the owner. Then the owner will pay that, by the end of July, maybe. And then they will turn around and then pay that out in August. Well, you've already used up most of that 74 days. If there's any kind of a hiccup or delay, like I said, that 74 days comes quick. What I have seen happen quite often in a larger commercial with clients that are mechanical, electrical, and plumbing contractors is that they will have that notice as part of their invoice when they send their bill to the contractor. That way they've already noticed the contractor. And then if they haven't been paid after 60 days, they'll send a copy of that invoice to the owner's authorized agent or owner's registered agent. Just a copy of the bill, with that notice in there. Or they'll get it to the architect, but they'll try to find some way to get it. Usually when it's included as part of the invoice of the contractor, the squeaky wheel gets the grease. And if you do that, as a general rule, it usually helps you to get paid. So here's the notice that has to be sent. Again, 74 days, no more than 74 days after the last day labor materials were provided. And it also has to be sent 10 days before you file a lien. So notice for property owner. Bills for labor, services, or materials used to construct or provide services for an improvement real estate are not paid in full. A construction lien may be placed against the property. This could result in the loss through foreclosure proceedings of all or part of your real estate being improved. This may occur even though you have paid your contractor in full. You may wish to protect yourself against this by paying the above named provider of labor, services, and materials directly, or making your check payable to the above named provider and contractor jointly. So the part that was underlined in the previous notice with the contractor, subcontractor, there's also 3 words that were added to this notice at that same time. So if you look at the top, it says if bills for labor, services, or materials used to construct, the words or provide services were included when all of those people were listed, because some of those people that were listed don't construct. Surveyors, architects, those type of things. So if the notice that you have that you've been provided by your attorney or that you've used for years does not include or provide services for, then you need to swap it out with the correct one, because if you do not have those 3 words, or provide services for forwards or provide services for, then your lien notice will be deemed invalid by the court because it will be the wrong notice. And by being the wrong notice, you will have deemed to have provided no notice. And if you haven't provided notice, then you can't file a lien. So that's the notices. So then in addition to that, so the notice, and when it says under 6, the notice, that means the 10-day notice, right? The 10-day notice before you file a lien that you're providing to the owner, or if you're a subcontractor to the owner and the general contractor, shall contain the following information. So a general description of labor, service, or materials furnished in the amount due and unpaid. So you cannot say, Bob's Plumbing provided labor, service, and materials to Acme Construction for the construction of Building B. You've got to detail what the labor materials were. You've got to say plumbing supplies and materials, or whatever it was. You can include a copy of the contract, and you can say provided labor, service, and materials as detailed in the attached contract, and that will satisfy it. But you cannot just simply state provided labor and materials. You have to have some form of detail. You've got to have a statement of account showing what is owed, and it should say any payments instead of nay payments. I apologize for that, have been made on the account. So the amount due and unpaid. So when it says amount due and unpaid, that's the amount due and the amount unpaid. So, just print out a statement that shows, everything you've invoiced, the payments you've received, what the balance is owed, and include that. That'll satisfy it. The name and address of the person furnishing the labor, service, and materials. More often than not, it's not a person, it's a company or an entity. So that would be the name and the address of the supplier of the labor, services, materials. You don't want to put the name and the address of who you supplied them to. I've seen that happen because then there's no notice. Because the owner, when they receive this, they need to know Bob's Plumbing hasn't been paid, and they need a name and address. And I put the phone number in there too, because the owner may call Bob's Plumbing and say, hey, I wasn't aware you haven't been paid. Send me your stuff and let's see if we can get this resolved. The name of the person who contracted for purchase of the labor, service, or materials. So if you're the general contractor, that would be the owner that you contracted with. If you're a subcontractor, that would be the general contractor. If you're a supplier, that would be the subcontractor or the general contractor. So you want to put the name, the address, email address, and phone number of the person that you contracted with. A description of the job site sufficient for identification. So you can't just put the street address. You can't put 101 Main Street because, as we all know, there are certain instances with commercial properties to where you may have a strip center. Well, the whole strip center is 101 Main Street, A, B, C, D, E, F. But if you just put 101 Main Street, which one is it? And so they changed that a few years ago, so it cannot just be the street or the physical address. Sometimes in commercial, new commercial, there won't actually be a street address because it'll be a lot in the block, depending on what stage you're at. And so you can do the street address, but you also need to do the legal description. You can get that from the tax assessor's office in Arkansas. And then the following statement set out in boldface and all cap letters, that's this notice. So that notice with all this information, and that has to be provided 10 days before you file a lien. So 4, 10, 74, and then 120. So people always ask, why is it so nitpicky? Why can't I just, why can't I just be close enough? Why does it have to be perfect? Well, that goes back to the 2000 case of Books a Million v. Arkansas Painting and Specialty. So this is the case from the Arkansas Supreme Court that set that golden rule that everything has to be complied with strictly, meaning every word has to be perfect. If it says bold, it has to be in bold. If it says all capital, it has to be all capital. If it says 74 days, it's 74, not 75. So I'll just read this through. So it's long been held that mechanics liens are in derogation of common law. The material liens lien and construction mortgage lien are in derogation of common law, and both are creatures of the legislature. So in derogation of common law means that those, as it says, they're creatures of the legislature. Mechanics liens were created by the law, by the legislature, to give contractors, subcontractor suppliers an extraordinary remedy that no one else has. You can attach your debt to the property. No one else has that in commerce. So our lien statutes are a derogation of the common law, and we construe them strictly since they provide an extraordinary remedy that is not available to every merchant or worker. Here's the key. The notice requirements are for the benefit and protection of the owner. So that's the key. So the reason why everything has to be done exactly perfect is because the notices are for the benefit of the owner, not for the benefit of the supplier of labor, materials, or equipment. Therefore, because, and let's go to the next one, the notice provisions must be complied with strictly. And so in that case, Arkansas Painting sent a notice. It was defective. They then sent a corrected notice on March 14th, but that was after the 75th day. And so the Supreme Court said that the second notice, while correct, the first notice was incorrect. The second notice, while it was correct, was sent after the 75th day. Therefore, there was no lien because it did not comply with the 74-day rule. But it went above and beyond that when it said that the notice requirements for the benefit of the owner and that they have to be complied with strictly, meaning every I has to be dotted, every T has to be crossed. It's got to be bold if it says bold. It's got to be caps if it says caps. There's a lot of other details as far as how it's got to be sent and all that, but today's webinar is mainly to give you a bird's eye view of the common mistakes and the required notices. And, I can't impress upon you enough to remember 4, 10, 74, 120. More than 4 units is commercial, not residential. You have to send the lien notice 10 days before you can file your lien. You have to send that 10-day notice before the 75th day, which means no later than the 74th day. So it's easier to remember 74 than 75. And then you have 120 days from the last day you filed, from the last day you provided labor, services, material, or equipment to actually file the lien in the county where the work was performed. So 4, 10, 74, 120. So that's all I've got. This is supposed to be kind of short and sweet. I ran over a little bit over my time. And so Diana will tell me if there's any questions.
No, Don, I do not see any questions at the moment.
Okay, well, I appreciate everybody taking the time out of your morning. I hope that you learned something. And if you have any further questions of me, my email address and phone number are on the screen. If I don't answer the call, leave a voicemail and I'll return your call within 24 hours. It's easiest to get hold of me by email. But again, I want to thank everybody for taking time out of their busy morning. And I appreciate the opportunity to be able to hopefully give you some insight on how to get paid for work that you've done. Thank you.
Thank you very much. Have a sunny day, everyone.